I asked Carol Nick with the statewide benefits office to do a roll call of all SEBC members to document attendance.
Yep, so here in person, I do have Director Maxwell, Secretary Gordon, Jeff Pashner, Karen Peterson, and Bill Overly. Logged in virtually, I have Treasurer Davis, Director Stephen Constantino, Deputy State Court Administrator Ashley Tucker, Paul Bombach, and Controller General Miller. Is there anyone else I might be missing?
Ms. Nick, I'm very sorry. My internet cut out and I'm certain that you identified me. It's Kyle Gay. I just want to make sure you saw me.
Governor,
Thank you.
thank you.
Good. All right, I just have a quick announcement, as a reminder to committee members, due to the state's procurement processes, the committee cannot engage in discussion or respond to any outreach from vendors on active procurements, including the PBM and life insurance RFPs. The SBO will provide regular updates to the committee on the status of these procurements during the SBO's director's report agenda. All right, I'd like to move to agenda item number 2, which is the approval of the meeting minutes from the June 27th, 2025 SEBC meeting.
The minutes from the meeting of June 27th, 2020.
Have a motion, now a second, please.
Second.
Second.
Motion's been put forth and seconded. All those in favor say aye.
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 Those opposed? Minutes approved. Okay, that moves us on to, I think, agenda item number 3, which is the statewide benefit office director's report. So I'm going to turn it over to Director Hardis.
Thank you, Director Maxwell. Good afternoon, everyone. To start with some general updates on our active RFPs. The Pharmacy Benefit Manager RFP was posted on Tuesday, July 15th. Intent to bids from vendors are due by Friday, August 22nd, with a mandatory pre-bid conference call for all vendors intending to submit a proposal occurring on Monday, August 25th. For the Vision Benefit RFP, this will be posted on Friday, August 8th. Intent to bids are due by Friday, August 22nd, with a mandatory pre-bid conference call scheduled for Tuesday, August 26th. The life insurance benefit procurement is still active, and the SEBC can expect to review and vote on an award recommendation at the September 23rd SEBC meeting for contract effective July 1st, 2026. At the June 27th SEBC meeting, an update was provided to the committee on the launching of a new diabetes prevention pilot program through Highmark Delaware and Reciprocity Health. The pilot size was capped at 100 qualified members per the approval of the SEBC. I'm happy to report that we have achieved the 100 member enrollment on July 15th. The SBO will continue to monitor the progress of this 12-month pilot and will report outcomes and recommendations to the SEBC on a regular basis. I did just also want to note, as we did very quickly hit that 100 member cap, Highmark and Reciprocity Health will be reaching out to other members who were invited just to gauge their interest to provide our recommendation to the committee, since we did reach this 100 limit quite quickly. And the final update I have, as the committee is aware, the weight loss GLP-1 drug Zepbound was removed from the CVS standard formulary effective July 1st of 2025. It was recently identified by CVS that some Zepbound prior authorizations were terminated without following the standard process for notifying members. 210 affected members had their prior authorizations terminated on June 30th without receiving the disruption letter. To resolve this issue, impacted members' Zepbound prior authorization termination dates have been updated to July 31st, 2025, essentially giving them an additional month of coverage. This adjustment ensured members received proper notification before termination of their Zepbound prior authorization. And again, only applies to a small subset, 210 members. However, we have expressed with CVS concerns with that going forward to ensure that all members are properly notified for changes to formulary and prior authorizations. Any questions on those updates?
I just wanted the committee know that the insurance commissioner has joined the meeting.
Thank you. All right, that's all I have for today. Thank you, Director Maxwell.
Thank you.
Bill Everly, will we have an opportunity at some point to revisit the prior authorization issue
Yes.
on
absolutely.
GLP-1s?
Yeah, absolutely. And there will be some discussion today with WTW's trend development discussion. There have been some revised trends for fiscal year 26 for GLP-1s that we very much want the committee to engage in robust discussion on, which would again go into that discussion of prior authorizations as well.
All right, so I move to agenda item number 4, which is proposal review committee PRC composition. We do have Caroline McDonough from the Attorney General's office, who's going to give us some information regarding this topic.
Thank you. Hi, everyone. My name is Caroline McDonough. I'm filling in for your dad, Michelle Wallen, today. I represent the Department of State in my normal job, so I am familiar with state agencies. I want to preface this with 2 items. One, as Director Maxwell mentioned, I'm going to speak as broadly as possible about the SEBC's perspective and treatment of subcommittees. The proposal review committees for the various RFPs before the SEBC right now are the most pertinent topic, but what I'm about to say applies to all subcommittees. I know that there are a few other subcommittees other than the proposal review committees. Second, and just as importantly, what I'm about to say is merely my legal advice. You all are free, as the SEBC decides to, continue on the way you have been. I recommend following one of 2 options I'm going to set forth, but please know that I'm here to provide advice and counsel. I am not the decision maker. I am not telling you that you absolutely cannot do something or that you absolutely must do something. I am here to counsel you. So please just keep that in mind. It's yours, the SEBC's decision to make ultimately. So getting into it, it's my understanding that the composition of the various proposal review committees and all subcommittees for that matter of the SEBC mirror the composition of the SEBC in total. I know that in maybe all of the RFPs or maybe just some of them, the membership of the proposal review committee cites to the statute that lists the composition of the SEBC. That's 9602 D1A. Under that same provision, a quorum of the SEBC is defined as a majority of its voting members. That means that for the subcommittees, including the PRCs, if there's a quorum of voting members present, you have created an SEBC meeting. So a meeting of the SEBC. I don't want to say the full body because I think I was told that's a term of art with Robert's rules, and that's not what I'm intending to communicate. But it doesn't matter what you call it, whether it's a proposal review committee, subcommittee, etc. If you have invited a quorum or a majority of the voting members of the SEBC, what you have in effect is a meeting of the SEBC. So in general, subcommittees should always be comprised of less than a quorum of voting members. So that for the SEBC, that means all subcommittees, including the PRC, should have 5 or less voting members. Typically, and I'm sure you all know this, subcommittees are used by public bodies to allow for a subset of the group to dig in deeper to a topic or a subject and then report back to the entire body on their findings and maybe make recommendations, suggestions, etc. for the full body to take action on. So there's one option here that I see. It's for the SEBC to designate the PRCs and all other subcommittees as a true subcommittee. That means agreeing amongst the members of 5 or less people, 5 or less voting members of the SEBC to serve on each of the various subcommittees, including the different PRCs. However, if you feel that the subcommittees, including the PRCs, are better served by having all SEBC members present, so having the PRCs and the subcommittees look the way they do now, membership-wise, then these meetings should not be called subcommittee meetings, and they should be treated as SEBC entire body meetings. So taking those 2 options, on the question of whether non-ex officio members can designate people to serve in their place in quote subcommittee meetings. If you all agree that all of these subcommittees should look the way they are now, they do now, and have all members of the SCBC be invited and be present in the subcommittees, the non-ex officio members should not be permitted to designate people to serve in their place. Because, as I think you all know, 29 Del C 9602 A1H prohibits non-ex officio members from naming designees to serve on SCBC meetings. So you all can designate people to serve in subcommittee meetings, but that is if you all decide that PRCs and subcommittees will resemble true subcommittees based on the meaning of the word, 5 or less voting members. So that's really the two options that I see. I to the extent it's helpful. This is a topic that I discussed in length with Michelle Wallen, your normal DAG, as well as other colleagues in the civil division of the DOJ. And it's something that we agree makes the most sense based on the statute. So if you have any questions, I'm happy to answer them.
So just to clarify, it sounds as though what you're saying is that a PRC or a subcommittee, as defined as a subcommittee, would have to have 5 or fewer members. That's one option.
Yes.
And the other option is for it to reflect the SEBC membership in general, which would not allow ex officio members to have stand-ins.
No.
Non-ex officio members.
Yes,
Yeah.
non-ex officio.
Yes.
Thank
I
you
didn't
for
know
the
a better way
clarity.
to describe it.
No, that's okay. That's
Yeah.
That's the clarification that I'm looking for.
Yes, that is correct. Yeah. Oh, sorry.
Karen Peterson.
I have a couple of questions, Carol.
Mhm.
Back to the issue, all right, the issue that brought all this up was an email saying that we appointees not appoint designees to the PRCs, which historically has always been the case. They could, but all of a sudden now, for some reason, they're saying we can't do that because the law says that appointed members may not attend committee meetings through a designee.
Yes, the full committee meetings.
Let me just, I made a copy of this, usually just to hand this out. I want to make sure I understand what we're talking about.
Is there a way for you to make the documents available even if someone's able to take a picture of them and send them to me?
Talking about section 9602 of Title 29, State Employee Benefits Committee. The first sentence says, the State Employee Benefits Committee, parentheses, quotation marks, committee, right, is comprised of the following voting members or designees selected by the members serving by virtue of their position. Okay, so that tells me that references to committee within section 9602 is referring to the State Employee Benefits Committee. Is that correct?
Yeah.
Okay. So when they say that appointed members may not attend committee meetings through a designee, they're talking about the SEBC committee meetings.
Yes.
Okay.
Yes. Yeah.
So why are we now being told that we can't be on the PRC because it's a committee and we're not allowed to attend committee meetings through a designee?
So I'm certainly not saying that appointed members are not permitted to attend PRC meetings.
No, but
I'm not sure I followed
we're
the
being
question.
told that we cannot designate
Mhm,
a person to represent us on the PRC
mhm.
because it's a committee. And the law says appointed members may not attend committee meetings through a designee. So it's on 4 of us that we cannot have any designees in
Yes,
the PRCs.
because as reflected now, the composition, it mirrors the SEBC. And so it doesn't matter what it's called. You have A PRC meeting right now, if it were to happen tomorrow, is a meeting of the SEBC. In
Is it-
name, it's not, but in effect, it is.
Isn't it a committee of the whole?
Yes, that's what I'm saying.
Okay,
Yeah,
so are these subcommittees. Every member of the SABC appoints a designee to the subcommittees,
yes.
and we all have designees, even under the resolution. We have designees to that
Mhm.
committee of the whole. So what distinguishes this committee of the whole from that committee of the whole?
Nothing. That's what I meant when in the beginning, when I added that little disclaimer. The PRCs are the most pertinent topic right now because there are many active RFPs. But what I just said applies to all subcommittees, whether the ones that were created by resolution, whether the PRCs, any subcommittee that I'm aware of the SEBC, I believe, is comprised of everyone on the SEBC.
And the law says that we can have designees to subcommittees,
Yes, but what I'm saying is that's not a real subcommittee. In effect,
but
it
it's
is,
not a subcommittee at all. I've said this for the last 6 meetings.
and yeah, and that
It's
is
not a subcommittee, it's
Correct.
an advisory committee.
I think that was partially why this topic. came
exactly,
up.
yes, because you raised this excellent point, and it caused us to look deeper into the issue and realize it doesn't matter what you call it, it is a meeting of the SEBC.
So the SEBC can write whatever rules it wants. So it could say for committees of the whole, all members of the SEBC can appoint a designee. There's nothing to prohibit that. It's a committee, but it's a committee of the whole. It doesn't make it an SEBC committee meeting.
See, that's what we disagree on. We believe that it does, no matter what you call it, you can call it a subcommittee, an advisory committee, et cetera, based on the definition of the SEBC quorum, 9602 D1A, a quorum of the SEBC is the majority of its voting members. So anywhere you have the potential to have a quorum of or the majority of voting members, you have in effect created an SEBC meeting.
Okay. So the law goes on to say that whenever there's a meeting of the SEBC, which you're saying these subcommittees are,
Yes,
and PRC is, the law also requires that the chairman or vice chair be present for all of them and preside over them. Is that
yes,
what you all had in mind?
Yeah,
I at least-
that's why I hit the pause button on resolutions, because that's definitely a time commitment for the vice chair and myself.
And for the 4 of us, we would right now be serving on like 6 PRCs for crying out. Everybody else on the committee has staff, paid staff that they get to send to all these meetings. We don't have any paid staff. You know, we're it. And to expect us to serve on every single PRC, which I know the ones they've already had have been time consuming, the ones coming up are even gonna be more time consuming, especially the PBM. But I mean, isn't it true that the SEBC could pass a resolution saying that except for these formal SEBC meetings, that all members of the committee can appoint designees? I mean, you could say, and that's what the resolution says right now, on the subcommittees. But, you know, and to the RFP issue, I mean, technically you could say the PRC shall be made up of the several dwarfs. I mean, that's the SEBC committee's decision to make.
it is, but only if it doesn't run contrary to the provision. So the example you just gave would not run contrary to anything in the code, but created a resolution that says only this certain subset of SEBC meetings should be treated as formal SEBC meetings. And then these meetings will be treated as different, would conflict with the code because only appointed members are permitted to attend subcommittee meetings through a designee. And it doesn't matter what you call it, like I said, or how the resolution defines it. If there is a majority of voting members, you have a meeting at the SEBC and that would run contrary.
So for example, if, I'm just thinking about like, if I were to send an email to every single person here or every single person except for one, that would still be considered an SEBC meeting.
Well,
We've
it's considered
established
a
a forum
constructive
in
forum.
that,
It'd be a
in
constructive
that
forum.
scenario.
Right.
Right, so again, I think it part of, I would like to kind of address that, is that considered a quorum?
So you have a quorum over email, but it's really fact specific. It depends on what type of information you're communicating If it's the passive receipt or, sending of information, you're not discussing public business, which is what a public body meeting is defined as. But if you're engaging in substantive discussions and offering opinions among all but one over email, then you have created a
Or
committee.
essentially 5 members.
Yes, exactly.
Then that's-
I think your quorum is 6.
Six.
Yeah.
So when I asked,
Karen Peterson.
yeah, so when I asked a question in writing last week, what sections of the law were relied on to make this determination? Because I was interested in just doing my own research. I was told that, that I couldn't get an answer because it would violate FOIA. Well, I'm pretty familiar with FOIA, having written long sections of it in my years in the Senate. I still can't figure out what section of FOIA would prohibit them from answering a question. Just, I'm not looking for a discussion, didn't copy all the members of the SCBC, did not reach a constructive forum. But I'm concerned because now if we ask questions, do we just get blown off and say, well, legal counsel said that's a violation of FOIA. And it clearly was not a violation of FOIA. So I'm concerned about that too.
So I have a few points I can address with that. So first, this pertains to all written communications over email, not just the example you're describing. It's really not the Deputy Attorney General's practice to provide written legal opinion. That's not a workable use of the DAG, a DAG assigned to any public body. The purpose of the DAG, who represents a public body, is to receive a request from the public body on behalf of the public body at a public meeting to then, conduct legal research, provide legal advice, etc. You are absolutely correct. The FOIA does not have a provision that says you can't discuss legal citations over email. But of course, not every statute or article of the Delaware Code can anticipate and contemplate every circumstance in which the applicability of that statute could arise. So I will readily admit that it was me and Michelle's conservative approach. But we believe that a discussion of the interpretation of FOIA, or excuse me, not FOIA, the SCBC's enabling statute as it pertains to subcommittees and the treatment of those quote subcommittees by the public body is veering very close into a substantive discussion of the public business of that public body.
But couldn't 4 of us have a discussion,
So
a substantive discussion without violating FOIA?
So it's a good question, and it's not something that's in the code, but it's something that's been addressed by Attorney General opinions, that technically, yes, in the code, a public meeting is defined as a formal or informal gathering of a quorum of the members, but there are a few AG opinions that have found FOIA violations when actions are taken by a public body to try to pass FOIA muster just because you have 1 or 2 or 3 less than a quorum. It's just a violation of the spirit of FOIA. Yes, there's not a quorum, but to pass by on that technicality of having 2 less people than a quorum, it just runs contrary to the intent of FOIA to have all public business be discussed in public.
It might run up against the spirit, but certainly doesn't run up against the law itself. But, when I get an email saying, you all can't appoint designees anymore because the legal counsel has reviewed this and blah, 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 blah. And my question was, can you tell me what sections? So I asked for it. And I get this, no, we can't, it's a violation of FOIA. And
So it's just
I
not,
felt like I should be like sandbagged.
it's just not good practice to discuss public business, whether it's the interpretation and applicability of legal statutes.
Yes, them, what the sections were.
Yes,
I didn't ask you.
but she would have gotten the sections from her legal
That's
counsel.
what I hear.
Yeah.
I didn't ask you, I asked.
So as her legal counsel, we advised her to wait to have this discussion
And you
in
will.
public. And
And
this is what I said in the beginning. This is
3
my,
people can have a discussion and not violate FOIA.
okay, so like I said in the beginning, this is my legal opinion. You're free to take it or leave it. I'm not trying to make you make a decision. I'm not the decision maker. I'm not on this body. It's my legal opinion. You can disagree with it, but I don't have to approve what you all eventually decide to do. But this is my legal opinion, and I'll leave it there.
Lieutenant.
Well, Lieutenant Governor's hand is under you. So turn it over to Lieutenant Governor.
Thank you, Director Maxwell, and thank you for the discussion. And I apologize. The Deputy Attorney General's back is towards me, and ma'am, I didn't catch your name.
Caroline McDonough. We met.
McDonough, Miss McDonough. Yeah, it's good to see you.
You as well.
I wanted to first of all just ask. It's okay. It's all good.
Sorry.
You can turn it off. I just want to first of all ask that we are treating Michelle and Ms. McDonough in a way that we would, as a group, wish to interact. And so while they do work for the committee, I really want to make sure that they are partners in figuring this out. And I heard very clearly from Ms. McDonough that her job is to give us choices. And so I'd like to discuss both of those choices because I see that there's some consternation with choice number one, which is that there are certain members that would have to serve on every PRC. And so there were other options offered, which is that we could create true subcommittees. And I think that we need to think about our options if there is such consternation with one of them. The second piece that I'd like to put out there as the director would like to just to determine the conversation here is that I thought I heard Ms. McDonough say something about the RFPs themselves and how the RFPs guide the composition of our committees of the whole, our subcommittees that were previously called. And so I'd like to just have some clarification, Ms. McDonough, on that piece and whether we have options related to RFPs that have already been approved, or if we do not have options, we only have options moving forward. That's my confusion.
Yes, of course. Thank you. Can you hear me okay if I'm facing this way?
I absolutely can. Yep. Thank you.
Thank you. So it's a great question. As far as I understand, there are multiple RFPs that are, you could consider active within the SCBC, excuse me. I believe there are a few that have not received bids yet, and there is at least one or two that have not been decided yet. The bids are in, but there's still a good amount of time until, you know, that decision-making process is made. After discussion with Director Hartos, Michelle and I think that with respect to the RFPs that have not received bids yet, what you all decide to do with respect to option one or option two can be implemented into the RFP process, selection process for that one, for those two, excuse me. The question of whether the RFP will need to be amended is a different question. The language of the RFP will need to be amended to reflect a change, if you all choose to change the composition of the PRC. But we think that that's still can be implemented, you know, for example, if you all choose to make it a true subcommittee. With respect to the RFP that has received bids, but the decision-making process is still underway, we also think that the SCBC can implement one of two options, a treatment of the PRC for that RFP as a true subcommittee in which you would all name 5 or less voting members to serve on that PRC, or again, it could look the way that it does now, reflecting the composition of the SCBC as a whole. Of course, if that second option is chosen, then we would advise not to permit the appointees to name designees to serve on that PRC. So we think, you know, whatever you all choose, if you choose to follow either of those options, can be implemented for all. I think it's 3 active RFPs. Of course, you know, there's we try to avoid as much risk as we can, but I understand that these RFPs are really important to deliver the services they are, you know, procuring for, and so we think that it's possible to implement either choice for those 3 RFPs at this time.
A follow-up question on that, and that is, where did the number 5 come from? As I know, subcommittee is a subset of the committee,
Yes,
and what does that mean?
the 5 number.
Yeah.
So I believe that the SCBC has 11 voting members. I think 1 non-voting member. So a quorum of the voting members is 6. So as long as you have less than 6, so 5 or less, yeah, that's all.
Thank you.
It doesn't have to be 5. It could be 2, but that's where that came from.
Lieutenant Governor, are
Mr.
you
Chair.
done? Hold on. Lieutenant Governor, are you done with your questions?
I am, and Director Maxwell, I don't have a motion at this time, but I think it's important for all of us to think about whether a motion is appropriate based on the conversation about the modified RFPs and the ongoing processes. I will continue to think about that as well.
Bill Oberly.
Thank you, Mr. Chair. I'm just trying to figure out how I'm not going to spend the rest of my life doing PRCs.
Understandably,
Um,
understandably.
And the original citation you gave, Title 29-9602, was the 2A,
For the,
D2A.
B2A, yeah, B2A. You know, it's interesting, we have the author of this legislation on the
Yes.
line. It'd be curious to hear Paul Baumbach's input on this question.
Can I, thank you, and Mr. Chair, with your permission. First thing is, I am unable to raise my hand, which I don't know if Carol can make some adjustments so I'm able to do that. That would be great. There's no chat ability either, so I've been a little bit limited in participation. And Ms. McDonough, I really want to thank you for helping explore the complexities involved with a sort of an unintended quorum and the implications there. It's an excellent point. I do note that there's explicit language that says that except for the RHBAS, appointed members may attend subcommittee meetings through designees. So clearly legislative intent to permit the appointed members to make designees for less than the full meeting. And now you're, of course, pointing out that really in an unintended way, we're making every meeting a full committee meeting. So that therein lies the conflict. Given that there's clear legislative intent, I would say there's a third alternative, which is to go to the legislature and ask them to update language to handle this kind of situation, to figure out if a body, in this case a subcommittee, has non-decision making other than only has recommendation making ability, that perhaps there could be an exception to the open meeting rules, the FOIA rules, or more explicitly in here. But indeed, we want to keep Mr. Oberle sane and not having to attend every PRC. I do take issue with the issue of not sharing the opinion. I think you were very clear saying that you and other DAGs view your role as advisory and providing advice to the body. However, that advice didn't make it to this body. It made to a subset of this body. And I really take issue with a unwillingness to share that and put it on the public meeting so it's available to the public, so it's not a FOIA violation. Not having that means that we were not able to understand the points, the very fine points that you and Michelle were making until this meeting began. And I think that really was a disservice in hindsight, which is why Senator Peterson and I were advocating for sharing of that ahead of time. But I think I think there's more than two choices. Maybe there's two choices immediately, but we also know the way that the FOIA law is interpreted is we can, as you say, we can decide to do what we want. But then what you didn't explicitly say is we open ourselves up for a suit saying we did things wrong. And that's where a lot of times bodies listen to their DAGs and their advice to try to avoid those kind of situations. But I worry, are you, I shouldn't be asking, does this make past PRC's actions illegal? And it's when there were designees in there from appointed members in the way that we operated in the past before this opinion was shared. I sort of don't want to think about that, but we sort of have to think about it. I would like to give the legislature the opportunity to get input from this body to see if they would consider making adjustments to enable us to act in a way that we think is more effective for the mission of this body. And I'm not sure that those two choices alone are sufficient to accomplish that. Thank you.
Jeff Tashner.
Thank you, sir.
Hi, I'm Jeff Tashner. I'm the executive director at the SEA, but I also sat in your seat for 9 years as a prosecutor and member of the civil division, so I understand exactly what you're doing, exactly the position you're in. I have a couple of questions just so I understand the parameters.
Absolutely.
And then Brian, I'm going to do what I always counsel people not to do. I'm going to think out loud about a possible solution so other people hear my thoughts. And they may be channeling some of the lieutenant governors, so I'll put that there to start. So the one question I have, so I can try to understand this, and for everybody, Bill pointed out that this is in House Bill 282, but the origin of this language was actually a previous bill, Senate Bill 29, which was the one that came about after the Medicare Advantage situation and created the RHBAS. That's where this language first came from, and it was Senator Townsend who was the primary sponsor. I'm not going to get into it, but I had multiple conversations. So I understand what his intent was, and I agreed in it, but I'm not sure today that we actually wound up with language coming out of the process that met that intent. But that's where it came from. And the first question I have is, that bill also then created the Retiree Health Benefits Advisory Subcommittee and says that, I guess that's the one place that you can't have designees. So nothing of what you're saying today impacts the RHBAS, which is currently inactive. I was just trying to figure out that interplay.
Absolutely. No, you raise a great point. And it is, I don't want to say unfortunate, but the use of the word subcommittee for that, I think is different than lowercase s subcommittees.
Gotcha.
So we don't see it as impacting in any way that subcommittee. As outlined in the enabling statute for the SEBC, that subcommittee is really just a creature of statute as we see it, and it's separate from that analysis. And very importantly, I believe, and please correct me if I'm wrong, but that subcommittee's composition does not mirror the SEBC.
It's got some of the members and it's got some other members who aren't part of the SEBC.
Yes, okay. And so that's what, for that reason as well, we're not viewing that subcommittee as a part of this analysis.
And then the other thing I understood that was critical to your advice was the reliance on the quorum in the definition. And I'm not saying that it's wrong, but is there any Delaware case law that's interpreted that, or is that the advice from the DAGs, which quite frankly, in my opinion, is better sometimes than Delaware case law? But just have the courts dealt with this, or is it just the guidance that you and I probably at one time as a DAG would have given?
So when you ask if the courts have dealt, do you mean
the definition of I guess it would be a subcommittee being one that is less than a quorum.
In general.
Or is a subcommittee something that is just, I think what Karen suggested and others have suggested, something that's just less than the whole committee itself, but maybe more than a quorum.
Yeah. That's a great question. I am not aware of any case law. Oftentimes public bodies, as you know, like this, discussions about the meaning of public bodies and how their enabling statutes are interpreted don't always make it up to the courts. So I'm not aware of any case law, but I'm happy to look into it. And I don't, like I said, this is something that I've discussed at length with other colleagues in the civil division. So I would hope that someone would know if there was a case law. Yeah, but I'm happy to look into that to see if that impacts the analysis.
And Brian, now for the thinking out loud part. You may want to hold on now. So accepting the definition of less than a quorum means that we would have to have a subcommittee 5 or less. And what I'm going to just throw out for people to think about if we move in that direction. And I know Paul talked about a legislative correction, but let's be honest, that will not happen until they reconvene in January. And it's not going to happen right away. And we've got an awful lot of time and business between now and then. So we need to figure out either a solution that we can all live with and not go to them for a correction, or just we got to do something. So when I think about our current committee and I look at its makeup, I kind of divide it into a couple of groups, right? There's the electeds, which are the lieutenant governor, the treasurer. There's the insurance commissioner. And I'm not sure where you put the courts and the CJ in that whole thing. But there's that group. There's the group that are like the appointments, yourself, Vaughn, and Steve's representing the secretary of DHSS. And then you've got the union representation I'm part of, and the retiree representation, that's Karen and Bill are. So I think if we go to a subcommittee and we rely on a quorum, and that's 5 or less, one of the things we should do is make sure that each of those populations is represented, right? And if we go to subcommittee, as I understand, that would allow that the person could be a designee of the retirees or the union or whomever. So I know Kyle said she was working on a motion. I think she was talking about some other part of this problem. But I think for an interim solution, I would encourage people to think about if we do a subcommittee, if that subcommittee needs to be 5 or less, it should be 5. And we should make sure that we represent each of those 4 populations at a minimum. That's all I have for you today, right now.
Hold on, I think Steve had his hand up. Look at that.
Yep, thank you. Thank you, Mr. Chairman. One clarification. This isn't a suggestion, it's more of a clarification. Looking at the 2 options that have been laid out, do we have to use one of those options for every project review committee, or can we use one option for one project review committee and another option or the other option for, another, or does it have to be one of those options for all of them?
Take this one, let's you.
I'm happy to chime in after.
I believe, Steve, we would have the ability to choose. I mean, we put together the RFP, that gets voted on by the SCBC. The language with regards to a PRC is incorporated in an RFP. So it could become a discussion point every time we did a proposal. Or we could decide up front that this is the methodology we want to select going forward, or we can have flexibility. There's always going to be flexibility, I think, by the committee to exercise with regards to that. I will just say to that point, I will say that I've been in state government and county government for 14 years of my life. And the structure of a review committee is different in this circumstance than any other time I've really encountered it, where we really heavily depend on the actual office that supports the committee. So what I mean by that is like a lot of the reviewing would be done by the statewide benefits office, and they would come back to this committee and provide a recommendation, or we could direct them to gather professionals in the area with regards to the proposal to assemble a team to review those proposals as well. I'm not saying that's the path we want to go down. I just want to be on record and be clear that what we have today, somewhat untenable for some of us that don't want to live on a PRC for the rest of their tenure on this committee, that there are other options out there where you really depend more heavily on the administrative office that's assigned to support the committee. Karen Peterson.
And as a matter of fact, if you look at the procurement law, it specifies that it's the agency that does all this work. Doesn't say anything about a committee. Yeah, PRC or anything else. But I just wanted to follow up on what Jeff had said about make sure that each of those groups is represented. I would go a step further and say that each of those groups choose their representative.
And that would be legal under the guidance that we're given if we do it of a subset, not a quorum of the SCBC, which opens up the fact that you're able to add folks to.
And you make a very good point, and I just want to second the point that you've made. All of the RFPs that I have been involved with that pertain to, I mean, just to clarify, they're financial. Everyone that we've been involved with requires a specific amount of expertise to be part of that PRC. And it's important that we have that representation. So I second that notion that we are very conscientious about sort of building a team, whether it's comprised of the SBO staff, you know, or otherwise, that's actually has applicable knowledge of these very important contracts.
So Karen?
Time is ticking. We have,
It is.
what, three
You're absolutely right.
RFPs floating out there.
That's correct.
We can't wait for the generous assembly.
So
Can I pull a Jeff Tashner and do some more talking, thinking out loud?
Paul Bomback,
So, and truly building on Jeff's point, and when I look at the makeup of the SCBC, one thing to consider is to have one of the appointed pensioners, one of the appointed union reps, 3 members of the 7 by office positions, as decided by the chair. So of those 7 office members of the SCBC, some would say, yeah, I'd like to serve on this PRC. Some would say no. If there's exactly 3, we're great. If it's 4 or 5, the chair can speak with them and figure out who really, really wants to be on there. You end up with 5 members of the SCBC on that. If you wish, you can also offer to the non-selected retiree and union member the ability to designate an appointee, but they would not go towards a quorum because on this subcommittee, they would not have that power. I think the DAGs would agree to. But I think more importantly, getting this group down to 5 is probably helps the lives of the 11 SCBC members and maintains the balance across the courts, the cabinet offices, the elected officials, and the pensioners and the labor folks. So I just throw that out as perhaps a way to work within the options.
thank you for that. As we continue to the Lieutenant Governor has her hand up.
Thank you. At the risk of sounding like a contrarian, because I actually really do appreciate the solution that's been presented and the way that especially Representative Bombeck has continued to talk about it. I just also want to point out that we should frame a solution that's based on our ultimate goal. And I think that because we are good stewards here and we enjoy working together and we want to do well as a group, I think we're thinking about fairness as the goal. And that is a great goal. But really the purpose of our committee is to deliver the best services to state employees, retirees, and their families, and to, safeguard our taxpayer dollars. And so there are going to be opportunities and times when certain of us are needed in certain places. And I just want to make sure that we're not kind of just deciding it's going to be a way and fairness among all of us as individuals and organizations is the top goal, when in fact I want to leverage our knowledge bases and abilities as best we can to support our mission here. And that is not to say that it's a bad decision or a bad way to approach it as we try and figure it out in the short term, but let's just be more thoughtful holistically before we have a long-term and permanent decision.
Thank you for that. Do we have any other comments we'd like to make on this topic? Appreciate everybody's feedback. I want to obviously recognize Caroline for stepping in today for Michelle on relatively short notice. So I want to thank her for her work on this topic. Where I stand as the chair right now, this is not a voting item with regards to today's agenda, but I appreciate everybody thinking out loud. But I'm assuming it would be the committee's intent to bring this forward on the next agenda to really vote on something that either it's a stopgap measure or some flexibility that we want to build into how we want to move forward. I mean, sometimes we don't have the perfect solution right out of the gate. So I think there may be some massaging that we may have to do over time. But I appreciate the discussion today. Hold on, Bill Oberly?
Yeah, thank you. Bill Oberly. I guess, Madam DAG, I'm still a little
Call me
confounded. I'm still a bit confounded about the PRCs that are in process.
Yeah.
And I raised that issue with Stephanie at the outset. I mean, I heard what you said, but I'm not entirely comfortable with what you said.
Yeah, and that's, I mean, completely your prerogative. I recognize that the advice I provided aside from that is quite conservative. Obviously, as I think Mr. Bomback pointed out, hopefully you all knew what I meant when I said we want to avoid risk, to avoid the risk of a lawsuit. But that is one that's a little less conservative with respect to the RFPs. It's really a judgment call for the SCBC to make. On balance, does the SCBC think that there is more risk changing the RFPs that are currently in place because of bidders who have or may or will submit bids to that RFP, and a risk of them complaining about the process versus the risk of someone in the state complaining about the process, the composition of the PRC not adhering to the statute. Of course, this is the way that it's currently written, is the way that the SCBC has operated for a long time. It's never come up until you pointed out that they're not true subcommittees, which was really helpful, and it's led to this deep dive into what subcommittees on the SCBC look like. But it's really it's a judgment call for the SCBC to make, whether you're comfortable with which risk you're most comfortable with and how much you're willing to take on.
If I may, Director Hardis, Statewide Benefits Office, knowing that there is a life insurance PRC meeting scheduled for tomorrow, my recommendation would be that we cancel that meeting and reschedule following the August SCBC meeting. Once we have time for the SCBC to make a vote or a motion on what changes they would like to see for the PRCs. Thankfully, for the life insurance procurement, knowing that this contract wouldn't go effect until July 1st, we do have some time if we need to move the vote back from the SCBC to another month. Not ideal. We like to try to stick to timelines. However, understanding the difficulty of the situation and wanting to put further thought, we can definitely cancel the meeting tomorrow. It wouldn't require a motion of this committee. We would just cancel and reschedule for a later date.
My question was, when is the next PRC meeting?
Yeah.
I answered it. And the PBM RFP, there's still time to amend that, right? Depending on what.
Well, we don't actually have to amend the RFP because the language actually says may, it's not saying shall. So we can design the PRC to include everyone, or it can be a subset because it has the words may. But we've been because we haven't had this discussion, we've been operating that every member of the SCBC would have representation. And so we don't have to change the RFP. It's just a matter of coming to consensus on what may means.
Now, Pam Barr is the one who oversees all of these PRCs, right?
Correct. Pam Barr is our contract and RFP manager for the state.
Would she find life easier if she were dealing with 5 instead of 11?
Quite frankly, I would say as far as the administrative component, we're still holding the meetings regardless. We're still providing the materials. We're still doing the same internal review. I would say whether the decision is to have 5 or 11, the SBO would not have a preference. I would just encourage the committee to note that, again, if it is a committee of 11 per the statute, the chair or vice chair would need to attend in person. If it is a subcommittee, meaning 5 or less SCBC members, the chair would be required to be a voting member of the SCBC and also must attend in person.
Jeff Tasher.
So I just want to confirm something myself. The issue we're wrestling with today, and I'm asking this because I was on the SCBC in a prior life for a long period of time before Senate Bill 29. This issue came about because of the language that was added to the statute in Senate Bill 29 saying no designees. And the things we did prior to Senate Bill 29, this issue wasn't an issue, it wasn't a problem.
Yes, I mean, so the language you're referring to,
About the quorum and about no appointed member.
members for sub, yes, that is correct. That is what's created.
So the people hearing this don't think like going all the way back, we had issues. This became an issue because the way I read it, the language here says no designees. The guidance is that if it is more than a quorum, it's the committee. And once it becomes the committee, that statutory language applies, so that prior to that statutory language, we didn't have the same problem we're wrestling with today.
I believe that's the correct.
How many people are on the life insurance PRC? Is it 11 or?
I would have to double check. I believe we have all 12, but the 11 voting members.
So I guess one other thing as we're considering what to do is because they've just heard some information, they haven't started scoring or anything, right? Or I'm wondering if there's a way to cure the problem. You don't have to answer my questions.
I
Well, I
think we want to
think-
be careful with how we discuss an active procurement.
What I'm wondering is if there's a way to cure the problem we have with the life insurance RFP and the PRC is to take the PRC as currently constituted and reduce it down to 5 or less.
That is absolutely an option.
All right.
Yes.
Thanks.
I think,
Is it also correct that not only, I mean, we could have 11 voting members on that as long as it was ensured that there were no more than 5 participating in any of the individual meetings?
no.
I'm sorry, Michelle, Caroline, can you?
Can you,
Because I know this has come up with the University of Delaware Board of Trustees and a quorum. I mean, and city councils. It's when there's a quorum of members present, right?
yes, and so is your question, that,
As long as they didn't have any meetings with 6 or more members of the SABC.
without changing the actual composition of the
Yes.
CRC? It's not great practice to base your meetings on the, like the chance that only 5 people will show up. And in order to ensure only 5 people show up, I would imagine you would have to coordinate and ask people not to attend. Well, technically that may be, not a violation and it wouldn't meet a quorum. I would discourage the group from taking that approach just because it's not, it's not fulfilling the composition that was provided for and outlined in the RFP.
Okay, thank you.
Of course.
Lieutenant Governor, did you have your hand up?
Thank you, Dr. Maxwell. Just 2 quick things. One is I hear Mr. Oberle's question about it is our decision. I would just say, similar to Mr. Tashner, I've sat in these litigation seats before and have had to deal with, contracts going into effect January 1, and there's still not a resolution to litigation on the contract because of RFP mishandling on December 26th. And so I just, knowing how important these contracts are, I would rather take the most conservative outlook until, as Representative Bomback suggested, we have more of a legislative or permanent solution. And that's just my opinion to share with the board. I wanted that perspective to be heard because I do think that in this market, there is a lot of competition and there are a lot of different choices for this committee. And I don't want our good work to be tied up in litigation following a decision.
Thank you again, everyone. Caroline, you are now dismissed. I don't,
Oh.
you know.
She'll stay for the full meeting.
She'll stay?
Yeah,
Okay,
yeah,
all right. I
I,
didn't want you to feel obligated.
no, I'm locked out
Thank
my
you.
schedule, of
Okay,
course,
excellent.
absolutely.
All right, so moving right along to agenda item number 5, it's the 153rd General Assembly Legislative Review, and Kristen is going to give us an update.
I'll try to be quick because I know we're over a little bit on our time. Kristen Barclay Short from the Statewide Benefits Office, just here to provide you an update on 8 bills. And move to the next slide, please. SBO is currently monitoring the progress of 8 bills that were introduced this session that impact the group health insurance program, the SBO, and or the SEBC. We have evaluated all these bills and shared with the bill sponsors, the governor's office and the comptroller general's office, any fiscal and administrative impacts. Just for everyone's awareness, the second half of the General Assembly, 153rd General Assembly will resume on January 13th and 2026 and will end on June 30th, 2026. Move to the next slide. Starting with House Bill 56, this bill mandates that all individual, group, blanket, and state regulated health insurance plans in Delaware cover the medically necessary removal of excess skin and subcutaneous tissue. This bill was signed by the governor on 7/21, and we do not have a fiscal impact because the SEBC is already in compliance. These procedures are currently covered when medically necessary under our existing health plans. Slide, please. Senate Bill 12 with Senate Amendment 1. This is known as the Delaware Pre-Authorization Reform Act of 2025. This bill strengthens the consumer protections by reforming how insurers manage pre-authorizations for healthcare services. It shortens the decision timelines for pre-authorization requests, clarifies who can make determinations, and standardizes how they are submitted, amongst other pre-authorization changes. This bill did pass both the House and the Senate and is awaiting action by the governor at this time. We have an indeterminable fiscal impact because any operational requirements would be incorporated in future contract negotiations. Okay, we can move to the next slide. Senate Substitute 1 for Senate Bill 134. This bill revises the definition of reverse auctions and permits the use of reverse auctions for the procurement of professional services for and related to pharmaceuticals or pharmacy benefit management services under the group health insurance program. This bill was also signed by the governor on July 21st, 2025, and takes effect upon being signed into law. So in law, we do not have a fiscal impact for this. All right. Senate Substitute 1 for Senate Joint Resolution 7 with House Amendment 1. This bill, joint resolution directs the SEBC to utilize specific strategies and policies when interacting and contracting with pharmacy benefits managers to achieve lower cost pharmaceutical drug benefits plans for the state. This is awaiting action by the governor, and we have a 0 fiscal estimated cost unless the SEBC, and depending upon any of the recommendations that the SEBC may implement in the future. Next bill, or next slide, I'm sorry. House Substitute 1 for House Bill 163. This bill establishes the Delaware Diabetic Wellness Pilot Program to manage and reduce the healthcare burden of prediabetes and diabetes among GHIP members. The program administered by DHR would involve 400 to 500 volunteer participants in a 3-year pilot. They would receive personalized care plans using physician-led teams and advanced technology through a continuous glucose monitoring and lifestyle tracking to reduce the cost and prevalence of diabetes in the group health insurance program. The bill is currently in the House Appropriations Committee, and we did estimate the cost of this bill at $5.8 million over the course of the 3-year pilot. Next slide. Senate Bill 117. This bill expands and updates Delaware's hearing aid coverage requirements under the GHIP for the non-Medicare health plans. It mandates coverage of medically necessary hearing aids and ear molds for individuals under 24 including 1 hearing aid per ear every 3 years or sooner if needed, and 1 ear mold per ear annually if prescribed. The bill is in the Senate Banking, Business, Insurance, and Technology Committee. And we do have estimated costs you can see on the screen for each year for this bill, should it pass. And Senate Bill 120, this bill mandates that all individual, group, blanket, and state-regulated non-Medicare health insurance plans in Delaware cover medically supported biomarker testing for diagnosis, treatment, management, or monitoring of disease. Coverage must follow FDA and nationally recognized clinical guidelines. It must be provided in a way that minimizes disruptions in care. This bill is in the Senate Banking, Business, Insurance, and Technology Committee. And we do have an estimated cost, you can see on the screen there, beginning in fiscal year 27. And HB 200 mandates that all individual, group, blanket, and state-regulated non-Medicare health insurance plans in Delaware cover medically necessary pre-exposure prophylaxis and the prevention of HIV infection before possible HIV exposure and post-exposure prophylaxis for prevention after possible HIV exposure. It also requires covered with no member cost share for services related to the administration of these medications. We have requested clarity on this because we just need clarity from the sponsor on language. It is in the House Economic Development, Banking, Insurance, and Commerce Committee, and until we get the clarification on the language, we don't have an estimated cost listed.
Thank you so much. We did get a request to shift the agenda by 1. We were going to go to agenda item number
Sure.
7.
Hi, Director Maxwell. This is Michelle Gass from Willis Towers Watson. Dave is actually on the line, so we can keep with the normal agenda if that's okay with the state.
That's great. So we'll go to agenda item number 6, request for proposals. It's the Health Data Warehouse RFP.
Great. All right. Good afternoon, everyone. Today I'm going to quickly outline the context for today's discussion. Then we're going to go over the feedback from SCBC members on the draft Health Data Warehouse RFP, and then we'll end up with next steps with regard to the RFP. As background, the state engaged Willis Towers Watson to support a procurement for health data warehouse services for the group health insurance program, the medical health management and pharmacy programs. The existing contract expires June 30, 2026. The SCBC will be issuing an RFP with a contract effective date of July 1st, 2026. During the May 30th SCBC meeting, the SCBC discussed the scope of services for the RFP and provided initial feedback. The feedback from the SCBC was incorporated into the data warehouse RFP. During the June 27th SCBC meeting, the SCBC was provided an overview of the RFP, which included the prior feedback obtained from committee members that had been incorporated into the RFP. Additional feedback was provided and discussed at that meeting. Subsequent to that, additional feedback was requested from the SCBC to be provided by July 7th in preparation of the data warehouse RFP's vote for approval today. We will review this feedback during today's discussion. Feedback from the SCBC members. Multiple members of the committee raised the issue of acquiring 4 years of historical data for the group health insurance plans, medical and PBM carriers. The committee members emphasized that at least 4 years would be needed to provide longitudinal analysis for things like GLP-1 medications, heart disease, etc. We shared that some carriers archive data after a certain amount of time and may charge a fee to retrieve archived data. Carriers may prevent the incumbent from sharing data from sending it to a third party. In this case, it would be a new health data warehouse vendor. To navigate this, the parties would be involved in a non-disclosure execution of non-disclosure agreements. Additionally, the incumbent Meritive would require the new vendor to execute a non-disclosure agreement before the incumbent could share that data. In this case, data refers to the raw claims data that the carriers themselves send to the health data warehouse before it gets normalized and aggregated into the data warehouse system. As generally speaking, health data warehouse vendors do not use data that has been aggregated or touched by other vendors. WTW recommended negotiating with the current medical and pharmacy benefit manager carriers now to commit to providing 4 years of history at no cost to the GHIP. This includes requesting that the carriers refrain from archiving the state's data effective immediately. The SBO agreed to make the request to refrain from archiving the state's data. The SBO reached out to Lantern, Highmark, and Aetna. All three agreed to share 4 years of claims data at no cost to the state should the SCBC select a new data warehouse vendor. CVS indicated that a small cost may be incurred. However, the SBO has copies of all files sent from CVS to Meritive, so likely we can avoid that cost. Additional feedback, the SCBC raised the issue of which entity owns the data in question. Some of the committee members assert that the data is the state's data and that the state should have the right to share the data as they deem appropriate. Other committee members acknowledge that ownership of the data is an ongoing point of contention, as carriers assert that data contains proprietary information such as pricing negotiations or negotiated pricing with service providers or pricing for medications. Some on the committee wondered why DTI and legal do not have a solution that addresses the issue of access of longitudinal data. WTW acknowledges that merits on both positions and recommends pursuing a resolution to the ownership question outside of the efforts of this RFP. The state's medical carriers, generally speaking, rather than the data warehouse provider, are the primary drivers around the data sharing constraints. WTW recommends negotiating data usage parameters and fees associated with sending data to third parties as part of RFPs with the state's medical carriers and pharmacy benefit manager. Some on the committee recommended asserting the state's ownership of the data as part of contracting with the medical carriers and PBM. WTW and SBO will work together to gain clarity for the SCBC on who owns the state's data. Additional feedback from the SCBC members, a committee member suggested that the criteria weight be adjusted so that financial terms be changed from a 20% weight to a 40% weight. WTW and SBO recommend that the SCBC discuss whether to adjust the criteria weight. Right. Additional feedback with regard to a line in the RFP, contract use by other agencies. The question was asked, how often does this occur? We learned that this is a general GSS template clause that is rarely, if ever, used for DHR contracts. If this occurs, do the same contractor parameters apply as well as pricing as defined by the PRC and approved by the SCBC? The answer is, if this were to occur, the same contract clauses, including pricing, would apply. DHR could deny the use of the contract by other agencies if it is decided that it would have an impact on the work performed by the vendor on the service DHR receives. All right, the next steps is the SCBC is to vote on approval of the final health data warehouse RFP.
Normally, just a quick question, I suppose, and some clarity. I was the one to raise the issue about the state's ownership of data. And you said that you work with SBO and the SCBC on who owns the state's data. I want to understand how that process will unfold and what you contemplate that will look like at the end.
This would occur outside of the of the Health Data Warehouse RFP. So that would to be determined. But for for the purposes of getting the the RFP executed and underway, we're recommending we pursue that outside of this this RFP.
Playing devil's advocate, why could that just be stated in the RFP?
I think the main reason for that is that it's going to I think it's going to be a drawn out an iterative process. This is an ongoing concern across the industry about who owns data, and it doesn't look to me from my perspective that it's going to be resolved quickly, and it would put the RFP in terms of delaying it at risk, in my opinion.
I would agree that this is probably an issue that can be addressed in both the PBM and the TPA RFPs. I just hope that we pursue that seriously when we get to that point. I'd rather see a cleaner solution, but I understand what you're saying.
Mr. Chair, should we be going back to the slide about the weights and considering coming up with a agreed upon adjustment?
I just want to make sure Dave has concluded his. Are you good, Dave?
Oh, yeah, I'm fine.
Go back to that slide, please. This has to do with the weighting of the scoring, and you have suggestions, Paul, or you want to weigh in on this?
So I guess I wonder whether the last PRC for the Health Data Warehouse was one where the financial terms, if it was a higher weight, would have had a different result. I'm a thrifty guy, but for a Health Data Warehouse, I wouldn't want to have my third choice on technology chosen over the first choice because of a 10% price difference. So, I could see squeezing 5 points out of this or that, but and I'm also a tech guy in background, so I wonder where you could get 20% from the other 80% categories. It seems like a big jump. So I don't have any specifics other than saying that sounds like a big ask to squeeze 20% out of the other categories to boost financial up to 40.
Anybody have any comments regarding Mr. Baumbach's assessment? Steve, your hands up.
Thank you. Stephen, Health and Human Social Services. I think for me, who's uses a lot of data warehouses in healthcare and other areas and other programs, I understand the financial concern, but to me, the most important thing are analytics. The ability for a data warehouse to answer those questions that we often ask. What's the trend in diabetes? What's the use of GLPs? What's the, is it unit cost that's driving our spend? Is it utilization? It's all those questions that inform us and on the program. And for me, that's the most important piece of this. And that's not to say, obviously, financial terms aren't, but you know, I would hate to base something totally on financial, and none of our questions can really get answered, you know, so that's just a comment on as we look at these the measurements.
Mr. Chair, I could throw out carving 5 points from account management and maybe even 5 from implementation to add to financial terms, but I'm not sure that's probably the extent of where I might have some comfort.
Would you like to make that a motion or,
We would include it with the full vote if there were any revisions. The criteria.
yeah, but I don't want to include it if we don't have support of the committee, so I'm looking for the desire of the committee, with regards to changing what's displayed on page 6 of the slide deck. Mr. Bomback had, just mentioned about trimming 5 points from account management and 5 points from implementation, which I would think would get you up to 30. My response to that, is I could probably be supportive of the account management, but implementation I think is still important. And going down to 5 would kind of devalue that category too much to my liking. It would at least get you up to 25 points, so it would be a quarter weighting for financial terms.
Works for me. So if you're looking for a motion, someone's hand is up, or was.
Governor?
No, I'll go ahead and second it. Go ahead,
Yeah,
Representative.
Chair Maxwell, yeah, I will move that on slide 6 and incorporate it into the RFP that we set the weight for account management down to 20 points and raise the points for financial terms up to 25 points.
I'll second that.
Have a motion and a second. Discussion on the motion.
I have a question. I'm just trying to follow, this is Jeff Tashner, trying to follow the conversation. Paul, do I understand that you're arguing for the increase on the financial terms, or did you also comment something about tools, technology, and analytic resources? Because I thought what I heard Steve saying is that he values that latter bucket. And what I don't want to do is I don't want to put an overemphasis on financial terms. So we're getting a product that costs us less, but doesn't have what we need to do the analysis we want it to do. And I'm just trying to follow the conversation and make sure that we don't solve what is perceived as one problem and create another. I think the most important factor here is the tools, technology, and analytic resources. Brian, I was looking at what you were doing, and I was wondering about the current account management and implementation. Is there overlap between the two of those so that we can carve a little bit out and combine it? But I really have a concern, folks, about going too much on what will be least costly and then not getting the tools we need to do the analysis we want, especially when we're talking about the data warehouse in the medical and the pharmaceutical field, and everything we've talked about for needing to look at the cost in terms of medical, the stuff around GLP-1s and that. I just not sure that this is the right direction to go.
That's what we're talking about. Go over it.
Yeah, and I guess I'm kind of in the same place Jeff is. I think if we were to pair 5 off the account management, I'd be more comfortable adding it to tools, technology, and analytic resources and bumping that to 30 as opposed to bumping the financial terms by 5.
Yvonne?
Yvonne Gordon. I think it's fine like it is. We tend to take
away, but we're the first to complain about the account management piece of it. And almost none of this happens without the ability to effectively manage the account. And when the scoring occurs, we all have our own technique for how we score. And you tend to score in 5, 10s, 15s, multiples of 5 or 10. So you will know the difference between the product and what's most important. And you start parsing off 2 points here, 5 points here. I think it's well managed. It's the numbers are percentages are well handled. I just don't want to take away from the account management piece of that.
Bill, did you?
No, having heard that, I will retract my comment. You deal with it, I don't.
Lieutenant Governor, did you have a comment, or I thought I saw your hand go up? You're good?
I'm good. Thank you.
All right, so we do have a motion and a second. We're having a discussion here. Paul, do you want to move forward with your motion? Or would you like to withdraw your motion? Because we kind of have 3 directions here, but it doesn't look like we have consensus on your particular motion.
Can I just ask Dave if because I don't remember the details of the suggestion from the committee member at the last meeting about boosting the weight for financial terms from 20 to 40 is a big move. Can he just remind us of where that came from to your memory?
And to my memory, it actually came as a follow-up suggestion. So I don't believe it happened during the meeting. It was after, and it was just a committee meeting. There wasn't a lot of detail to it. It was just a suggestion on the financials.
Thank you. Frankly, Mr. Chairman, I defer to you. If you'll let me, I'll defer to you. I'm happy to advance it. I will not be upset if we choose to not. You're running the meeting. I leave it to you. It's not burning one way or the other.
I think the correct answer is I'd like to withdraw my motion.
I would like to withdraw my motion, please, Mr. Chairman.
All right. So, looking at what we have here, I mean, we did talk about moving something. I think there's probably consensus in the room here to leave it as stated on page 6. And unless somebody else has something else that they'd like to discuss. Okay. All right.
Mr.
So that
Chairman,
leaves us.
Mr. Chairman, not on this slide, but I had submitted a question before by email yesterday about slide 13 and whether there really are only 4 leading firms that WTW had identified as appropriate to invite. And I admitted in my email that I know nothing about these other firms, and I wouldn't have been able to put the words together until I did a very advanced AI search, and quickly Google said, oh no, here are some other firms. Perhaps WTW could just give a quick comment of maybe these only serve corporations and not states to their knowledge, or some reason why we only had 4 versus the 6 that we had in 2020, and whether any of these guys were considered and then taken off a list for some reason.
Yeah, as far as my recollection went, I think we started with 4, and then when during the previous iteration, and then when it was opened up to the public, more submitted information, or submitted a request to bid, and that's how it expanded. How we developed the list that we brought to you today is these are more employer-centric data warehouse providers. They're ones that are our clients that we get to interact with periodically, that our clients work with, and they're the most established that we know of in the industry. These are the ones that we're most familiar with, and we know that they have at least some experience with very large employers. So that's how we developed the list.
I was just noting that the names of the, two of the first four included Amazon and Google, which, aren't small players in the overall world. Maybe in this area they are. But I also sort of feel like the RFP with already will take the folks out who don't have a presence in the space that we work. So this is not the only, I mean, all these RFPs, I always am mindful of, I'd rather have a big tent of invites, and even if only a few make it to the final round. So that's the reason I asked. You gave me an answer. I appreciate that. Just wanted to throw that out there. Thank you.
Treasurer Davis.
I mean, just for awareness, RFPs are made public. So these are just the individual entities that will receive sort of some direct outreach, but any and all, established firms can bid on this RFP. It's sort of a standard practice that if you have experience with a specific firm, that part of that relationship is that you would do a little bit of outreach to let them know that you have an open RFP. But other than that, everyone is able to bid.
And I'll just attest to that, like, most of the vendors that would be looking to do this, respond to this solicitation, sign up to get notifications of when things are coming out, so. So I think we're to the point where we didn't make any amendments to the RFP. So I'm going to read this, see if we can move forward. So regarding the health data warehouse request for proposals, which was distributed to the committee and posted publicly for review on July 22nd, would any committee members like to make a motion to approve the RFP as written to be advertised in August 2025 for an anticipated contract effective date of July 1, 2026? And a motion in the second. Any discussion?
Second.
Yep, we have a motion in a second. Any discussion on the motion? All right, I'd like to call for a roll call.
I'll start with the people in person. So I have Director Maxwell,
Yes.
Secretary Gordon,
Yes.
Jeff Tashner,
Yes.
Karen Peterson,
Yes.
Bill Oberly.
Yes.
All right, people elected virtually, Lieutenant Governor Cal Gay.
Yes.
Oh, I apologize.
It's okay. This is okay. I knew we would eventually. I mean, that's
I
as
did you
well.
virtual for a second. It's, so the highlight's different. So I apologize. Commissioner Navarre, I believe he logged off or had to leave. I didn't see him anymore. But if you're here, Commissioner Navarro, please say something. Oh, raise your hand. Okay, he's gone. All right, Director Stephen Cosentino.
Yes.
All right, Deputy State Court Administrator Ashley Sucker.
Yes.
Paul Bombeck.
Yes.
That's everybody. So we're good.
All right, motion carried. Thank you. All right, moving on to agenda item number 7, Aetna non-Medicare fertility benefits update. Going to turn it over to Michelle.
Good afternoon, everyone. Michelle Gass from Willis Towers Watson. I'm here to present the Aetna non-Medicare fertility benefits update today. So starting just with the contents, we are giving an overview of the GHIP fertility benefit changes under Aetna. The GHIP currently provides a $30,000 lifetime maximum for their fertility benefits under the non-Medicare medical plan. What is required for that today is a diagnosis of infertility or a medical condition that will cause infertility is required. Included in this $30,000 maximum are services such as ovulation induction, intrauterine insemination, artificial insemination, and in vitro fertilization. And the abbreviations are there, which I will use as we go throughout this presentation today. In addition to that $30,000 lifetime maximum for the fertility benefits, there's a separate $15,000 lifetime maximum for fertility drugs that is covered by CVS. Effective January 1st for the GHIP, Aetna will begin to cover artificial insemination or AI, and intrauterine insemination or IUI under the basic medical coverage. This will be subject to the member cost sharing and plan benefits, but it will not be subject to the $30,000 infertility maximum. This change has already been made across Aetna's book of business. This started in late 2024, but the GHIP had been granted an extension until January 1st, 2026. Effective January 1st, 2026, there will no longer be the ability for pre-certification, meaning the availability of checking for infertility and the medical condition, as well as the tracking of the cycle limit to move forward with the AI and IUI services. So what that means is the diagnosis of infertility that is currently a requirement for AI and IUI services will no longer be in place for the basic medical coverage. And this is a benefit equity enhancement that was not previously available for the Aetna plan in the core coverage. So what that means is same-sex female couples and single women will now have the ability to have AI and IUI with that basic medical plan coverage, and in the past they did not. The expected cost estimate per Aetna. So Aetna has provided an estimate on what they think this will cost, understanding that there were members that could not have this treatment in the past. So that is a 0.1 to 0.2 cents per member per month assumption, which is $32,472 to $66,206 annually. And again, this is due to the expansion of coverage to individuals who previously could not obtain this coverage. This estimation is again based on Aetna's book of business and costs and utilization. Historically, the GHIP's experience was in line with Aetna's book of business, but the actual impact could be slightly outside of this range and based on pre-existing infertility coverage and member demographics, and of course, other factors. The next couple slides are what Aetna has presented to the SBO in June of this year. So they really kind of break up for the group the ability to see what is the current coverage and then what it will look like after this change on January 1st of 2026. So you'll see this is broken up into a triangle, and on the right-hand side, it has basic in the top portion, and then there's two breakups of the infertility options below that in comprehensive and advanced reproductive technology. So as you may remember on the prior slide, I was focusing on the artificial insemination and the IUI specifically, which are currently listed under the comprehensive benefit. They are not currently covered with the basic core medical. Now, with the shift after January 1, 2026, you will see on the next slide that they shift and they no longer have this comprehensive benefit. AI and IUI will shift into your core medical, and then the OI shifts down into your advanced reproductive technology or ovulation induction. And then on the following slides, I'll go in further detail about what that means for the plan specifically. So again, just taking note that this is the current coverage for Aetna for your infertility benefits. And shifting into our next slide, you'll see that shift that I made mention of. So basic, comp, and art now shift to just basic and art, where basic on the top section is your core medical, which now includes your intrauterine insemination or IUI, as well as the ovulation induction shifting into advanced staying in advanced reproductive technology. The other thing to keep in mind here is, let me move into our next slide where this gives a little more detail here. So this lists it out in more detail. This is a summary slide by Willis Towers Watson to kind of break it up outside of the triangle for the group, showing that the comprehensive fertility section is now no longer listed and is kind of removed in that triangle view that you saw on the prior slides. You now have this breakup where the comprehensive fertility benefits kind of split between basic fertility and then advanced reproductive technologies. So artificial insemination and intrauterine insemination is now covered, and the diagnosis of infertility, which is now currently required, is no longer required for that treatment. where the ovulation induction moves down into your advanced reproductive technologies. Sorry, I said that slightly differently on the prior slide, but the ovulation induction shifts down into the advanced reproductive technology. And again, this comprehensive fertility row is now removed effective January 1st, 2026. And this is for the Aetna HMO and CDH Gold plans. Also to keep in mind that $30,000 lifetime maximum is now applicable for OI and ART or IUI specifically. Those are not, this $30,000 lifetime maximum is not applicable to AI and IUI any longer because they will now be in that basic fertility services and the regular plan benefits apply. So I'll pause there just in case there's any questions from the SCBC because I did a lot of talking. Does anyone have any questions? Kyle?
Hold on. Bill
okay.
Overly first. Yield to Lieutenant Governor. Lieutenant Governor, you're first.
Lieutenant Governor.
Okay, well, I hope I don't get in trouble with Mr. Overly, but thank you, Mr. Overly. I just wanted to, I understand the, equity in administering this. I appreciate the change. I just want to make sure that you're presenting this to us because this is a action that was taken on behalf of Aetna, correct, in restructuring, not, okay. And then,
correct.
So
this is something they've done across their book of business. It's not something that the SCBC would vote on in this case.
And I understand that this helps same-sex female couples and single women, but surrogacy is not included. Is that correct?
That is
or
not something that
fall
was
on a
covered.
separate type? Does that fall under a different type of coverage?
I would have to take that away and directly ask with Aetna, and I'm happy to circle back on that question.
I think that'd be great, just because if the purpose is equity across, then we just want to make sure that if it's not falling within the infertility bucket, we should understand what the services are that we're offering for other couples who may not be able to use AI, IUI, or OI as a means of starting a family. And then my other question is, does this apply to just the covered employee, or is this a benefit that's offered to the employee's family for if the employee is not the patient themselves?
My understanding is this is applicable to anyone that is on the plan. So the spouse of somebody that is on the plan, is that what you're asking?
Great. Yes, so the spouse would have to be on the state health plan in order to receive this benefit.
Yes.
Great, thank you.
Bill Overly. Yes, Bill Overly. I'm just trying to understand the diagnosis segment of this. Does that count against the 30,000 lifetime?
So the diagnosis,
Yes.
so in this first section, that is in the core medical. It's just that it is a requirement in order to get the advanced reproductive technology, which now has a smaller group of services, meaning it is IUI and OI specifically, where previously IUI and AI were also in that category and required you to be diagnosed as having infertility. Now that diagnosis is not required for these two services of the list that we covered. So hopefully, does that clarify your question, Mr. Oberle?
Not really. I'm just trying to understand the impact, or is there a negative impact on the 30,000 lifetime benefit?
No. So what I would say is the AI and IUI used to be counted towards that $30,000 lifetime limit or maximum, lifetime maximum. Now they are being treated with the basic fertility services, and it will not be taken away from that. So if somebody goes through, for example, IUI multiple times and it was not successful and they have to move forward into IVF, that $30,000 maximum would not be tapped into until they started the IVF services, where previously it would have already been tapped into with the IUI counting towards it. Does that make sense?
Yes, it does. Thank you.
Okay, no problem.
Steve?
Yeah, I'm just curious, how does Highmark plan deal with this? Is it similar, or Is this a better benefit? I'm just curious.
So currently, Highmark is the same approach as Aetna's current plan offering, meaning they have this breakup of basic, comprehensive, advanced reproductive technologies. We did work with the SBO to reach out to them to see if it was an option to shift to this approach, similar to how Aetna is. That is an option, and it does have a cost to it, which is something that can be discussed as well. But it is not currently in place for Highmark. So they, again, match similar to the basic, comprehensive, and ART, or advanced reproductive technology approach.
Thank you.
Yeah, no problem.
Director Artis, I think you had an answer to the Lieutenant Governor's question.
Yes, that is correct. I can respond to Lieutenant Governor's question regarding coverage for surrogates and surrogacy services. And this is directly from our fertility benefits FAQ document. The fertility benefits cover IVF using donor eggs, sperm, or embryos, and IVF where the embryo is transferred to a gestational carrier or surrogate. Coverage does not include the purchase of donor eggs, sperm, or embryos, medical costs outside of the IVF cycle, and received by the gestational carrier, including legal or other fees. Costs associated with the gestational carrier surrogate are not covered.
Thank you. I have questions, but I'll refer to the FAQ and we can take those up another time. It's not for today.
Absolutely, I'd be happy to circulate that FAQ to the SCDC.
Thank you so much, Stephanie.
Anybody have any other questions for Michelle regarding agenda item number 7? Great. All right, we're up to agenda item number 8, the financials. Brian, could you run us through the June 2025 fund report and financial update, along with the FY 2026 GHIP trend assumptions?
Thank you, Director Maxwell. Brian Stitzel from WTW. I'm just going to grab the screen share here real quick. Put it in slideshow mode. So jumping into the FY25, both June and year-end financial results. Relative to premium contributions, June came in significantly better than budget, about $9 million. That's predominantly due to the fact that the fund received 2 payments from the University of Delaware. Recall, UD is or has left the GHIP effective July 1st. Their premium payments have historically run in arrears, meaning they would have paid May's in June and June's in July, but they paid both May and June in June, which is why we ran about $9 million better than budget. The anticipation of getting an additional payment from them in July will obviously funnel through FY26 results. With that extra amount, premium contributions for the year came in about $1.8 million better than budget for the full fiscal year. So without that extra UD payment, it would have been a little bit more than $6 million shy of budget, which we know has been predominantly due to non-state participating groups running a little bit behind budget regularly on a monthly basis. Other revenues also came in better than budget in June, about $4.5 million. If we flip to other revenues real quick, you can see the additional amounts are coming through in this now in the other revenues category. So effective 1/1/25 under the Inflation Reduction Act, the different components of revenues coming to the GHIP due to the EGWIP program. The coverage gap discount program was replaced with the manufacturer discount program, fairly similar programs, but it's just a shift in categories where we were expecting about $4.8 million to be received in June, and in total, between the run out of the coverage gap discount plan and then the manufacturer discount program, which again is buried in this $8.2 million. Those two amounts came in a bit higher than expected. And then Additionally, there was a $3 million and change performance guarantee payment from CVS. So both positive, which ultimately led to total FY25 revenues coming in about $15 million better than budget for the year, partially driven by that, and partially driven by significantly higher rebates than expected on the AgWIP side. So again, here is the full $15 million better than budget for the full fiscal year. Claims fairly regularly throughout the course of the fiscal year came in ahead of budget. June was no exception, about $3.3 million better than budget, and roughly $20 million for the year out of the full $1.4 billion budget, or about 1.5% better than budget. So that was also positive news. And then expenses for the month of June came in just about right on budget, with a shortfall of about $7.2 million for the full fiscal year, mostly driven by that $6 million performance guarantee payment back to Highmark a few months earlier. So all in total, for FY25, the GHIP ran at a $96 million surplus, which was about $30 million higher than the anticipated $66 million surplus. In terms of long-term projections, recall the 4.2% approved for FY26, approved on a 3-year smoothing basis, meaning anticipating the same 4.2% rate action in all 3 of FY26, 27, and 28, with a projected singular year rate action in FY29, currently standing at 10.8%. All of these results are reflective of the current trend assumption. I know we're about to start a conversation relative to proposed and to be voted on FY26 trend assumptions. So these long-term projection results are using the current FY25 trend assumptions, as well as do not reflect the removal of Zepbound from the commercial formulary for GLP-1 weight loss drugs, in exchange for Wegovy, which comes at both a higher cost and a higher rebate amount, expected to produce net savings at the per prescription drug level. And then lastly, all 3 groups that we've historically talked about, active employees, pre-65 retirees, and Medicare retirees, all generally ran surpluses for FY25 across the board, consistent with the total FY25 results in the aggregate, noting that for FY26 and later, we are recommending, actually, I believe it was approved last year, that we would increase the desired surplus after reserves from 2% to 4% starting in FY26. And it was set at 2%, recall it, for FY25, simply because FY25 was that bad rate action year at 27%. So it was decided to take a build-up, phased-in approach to building that desired surplus up to 4%. So that's it on June and FY25 financial results. Let me pause there to see if any committee members have questions.
However, would this be an appropriate time to raise the issue around changes in formulary, particularly GLP-1s?
Would fall very well in line with the trend development discussion, particularly slides 5 and 6.
Yes. Well, honestly,
Do you want me to flip to the GLP-1 slides?
Mr. Chair, I've got a question for Brian on slide 15.
Sure.
Go backwards.
Yeah.
Go ahead.
Go
Ask your
ahead,
question.
Representative Bombeck.
Yes, so, and I emailed this to the chair and vice chair, late yesterday. I'd like an additional bullet at the top pointing out that 24,999 have a primary health plan that's 100.0. I'm sorry, get me if you can get me right, this is Medicare, right? So 100% of them, due to their lifetime employment, for which they continue to pay $185 or more monthly, for which the state pays nothing, $0.00. Yes, you are indeed presenting the dollars related to the GHIP, but the reason the GHIP pays so much less for these retirees is because they had paid and they continue to pay. And the absence of that can make it easy for a reader to misunderstand the balance of paying for employee and retiree health benefits by the state. So if you can reflect that these Medicare retirees, that the state share is low because of what these retirees have and continue to pay, not to the state, I think that gives a more complete picture of the dynamic of Medicare retirees.
Representative Bombach, are you referring to payments into Medicare Part B?
I am. Yes,
Okay.
I am.
Understood. We can certainly make note of that on the slide for sure.
I appreciate that. Thank you.
Any other questions on the financials?
No, we're moving forward to GLP-1s.
All right.
Well, I wanted to talk about changes in formulary generally, but given that there was a change recently from Zepbound to Wegovy, I use that as an example. I actually went to school last night for about an hour with an aggrieved state employee who was one of the ones that had a formulary change imposed. And quite honestly, I didn't understand the process of how GLP-1s are administered. There's a regimen apparently that takes place where they start out at low doses and then it's increased until over a period of time, it could be months, until they reach, I guess, a static level. And then it may vary moving forward, but it's a long process. And by making that formulary change, for those on Zepbound, we have negatively impacted them to the point where they have to go back to the beginning and begin the process over with Wegovy. And quite honestly, I don't believe we took a vote on the formulary change, or did we? I can't remember.
This wasn't a choice we had.
Yeah, it was not a choice that we had. But there are consequences out there that I think we ought to take into consideration when these formulary changes are made. None of us are doctors around this table. And quite honestly,
You have a medical license.
yeah, you have a medical license. I didn't understand the consequences, or quite honestly, I might have spoken up more. And I'm not a big fan of GLP-1s, as you well know, but I do realize in this one instance, the individual I talked with yesterday, they were pre-diabetic and had a legitimate reason for being on GLP-1s. I guess the point I want to make here is that, perhaps we ought to have some medical advice.
Yeah.
The SCBC ought to have access to some medical advice when these changes in formulary are being made. Clearly, I didn't understand the consequences, and quite honestly, I wonder whether this isn't a moneymaker for PBMs, because quite honestly, they've been on one GLP-1, and now they've got to go back and begin a months-long process with another GLP-1. And quite honestly, it's additional money in the pockets of PBM. So, at least from my perspective, I could be wrong. The one suggestion that was made to me is, if there is a change in a formulary, why not give state employees the option of paying the difference in terms of the cost as an additional copay, so they could remain on, in this instance, Zepbound, rather than go back and begin the entire process over again in ramping up the dosage. So I throw that out there for consideration. It looks like I have a supporter in the treasurer.
I would look to respond because I think that GLP-1s are a topic that has become, you know, very top of mind for a lot of us as a result of the innovation there. But this topic actually came up once before, and it was related to very high cost specialty medications. And at the time, I raised concerns because of the fact that what we were hearing from our CVS essentially was to make it more difficult for individuals to get access to their specialty medications. And I remember at the time sort of raising the concern that some of these medications are what keep them stable. You know, when we're talking about things like multiple sclerosis, rheumatoid arthritis, all kinds of autoimmune disorders. And we were making decisions that sort of, in our minds, lowered the cost. And that was sort of our focus. I think in general, it's extremely important for us to have the ability to have individuals who understand the full implication of what's happening to patients, to be able to kind of weigh in on some of these very crucial items. I will say that I have to commend the SBO because you often do that research ahead of time and you tend to sort of bring that stuff to us. I think there are a couple of components that we absolutely have to be considering as we move forward. One is whether or not the SEBC truly has the specialization that's necessary. And this kind of goes back to our conversation around PRC makeup. I think that's really important. I think the other thing that's extremely important as it relates to, you know, GLP-1s and coverage in general is that individuals are given more flexibility in how they utilize their benefit. It's also something that I've been bringing up for a couple of years, which is, Jeff knows this, do we think about moving in a direction of adding or offering a component of you know, a flexible, rather than a flexible spending account in HSA, and coverage that allows the individual to make that type of decision, particularly when this kind of thing happens. I believe, so please take it with a grain of salt, that individuals who are navigating their own complex medical challenges are better served when they can make decisions about how their care continues on between themselves and their medical professional. And I think that we should be empowering people to make those decisions. So as a general rule, because you brought it up, I think that it's important that we're thinking about the financial dynamics as well as how they impact people.
Yep. No, I mean, I couldn't agree more strongly with what you said. I threw out the possibility of, in the instant case with Zepbound, of exploring, and I don't know what an additional copay might run the average individual state plan to remain on Zepbound. I just didn't understand the medical side of this. And I've argued for years on the subcommittee that I think the final arbiter two arbiters ought to be the patient and the physician in terms of what is the best course of treatment. A decision was made based solely on financials as it related to the GLP-1 in this instance. And we, it wasn't made by us, it was made for us. Yeah, it was made for us. But we didn't provide any pushback. Quite honestly, I might have provided some pushback. Perhaps you did, but I didn't. If I'd known or had a better picture of the consequences, the impact that it has to the state employees who were receiving that GLP-1.
Jeff Tashner.
So when Bill explained this to me, probably when we were both driving to this meeting, what it triggered for me is in the medical coverage area, we have the concept of in-network, out-of-network. So that a plan member can choose to go out of network, knowing that they still can get the coverage, but there's additional financial cost to him. And when Bill was sharing this, it made me think, we don't have the same thing, Stephanie, you correct me if I'm wrong, in the pharmaceutical benefit. There's nothing such as formulary off of formulary. I mean, if it's not covered by the formulary, it's not covered, right?
That is correct.
And I think that's where it comes down to, like, would the same financial benefit we provide to the member if they were using a medication on the formulary still be available to them? But as Bill says, they pick up the additional costs. So in this case with the Zepbound, you know, we would pay what we would normally pay for the Wegovy towards the cost of the Zepbound, but the additional cost of the Zepbound would be on the plan member who makes that decision for themselves to go with the Zepbound. That's what it got me thinking about.
And that's exactly what I was advocating.
Can I interject a little bit there from, I guess, more of the financials side of that equation? Certainly questions that CVS would have to give clarity and answers back to, but typically when you look to modify the copay structure, the member copayment structure on the GLP-1 side, it has a significant impact on the rebate side of the equation, which could ultimately lead to the GHIP being ineligible for rebates on Wegovy altogether. Additionally, again, on the rebate side of the equation, the formulary change that Caremark made by removing Zepbound actually increased the negotiated rebate paid by Novo for Wegovy, such that the additional rebates coming out of Wegovy from what they previously were greater than the difference in the additional cost or the gross cost of Wegovy versus Zepbound, to the tune of, you know, the market price of Wegovy versus Zepbound. I think they're $300-400 difference. I'm not sure of the exact amount. Additionally, you know, members do have, when you start talking about numbers of that magnitude and the different price points, there are certainly cash assistance programs that are out there too, where people on Zepbound could go get Zepbound for honestly roughly about the same amount that the retail price difference is between Wegovy and Zepbound. But Bill, Jeff, all great valid points. I just wanted to add a little more clarity on the financial ramifications of those decisions.
So I just want to remind, and I appreciate that, Brian. You had me until you said rebates, because I know from our prior conversations, in my opinion, that's part of the shell game that the PBMs play. And I don't think we should just be quickly dissuaded. But I also, at the end of what you said, I think it's interesting, because part of the challenge is that the member may not know that they can go get Wegovy with, you know, the manufacturer's rebates and all that. All they're getting is, my medicine's not covered.
Sure.
And what do I do? And I know we've, in our organization, a lot of times those people will call in. They'll come to me, and in the past, I fed them to Statewide Benefits, who's done a great job working back with and helping them. But the problem is that probably happens a lot less often than the member who just feels, my benefit was taken away, what do? I got no choice. So I think we need, as we work ahead, to figure out kind of that, how do we thread the needle a number of ways to address the finances, the cost, as well as meeting the needs of the members.
Thank you, Director Maxwell. Director Hartis, SBO. To your point, I do want to let you know that when the members were informed of this change, when they were sent this letter from CVS, it did include on the letter that they can get the drugs direct by manufacturer using the manufacturer's discounts. Now that's still about $500 a month, as it is not on the formulary. But I completely understand where you're coming from. that was communicated in that capacity, but again, that $500 a month price tag is still incredibly unrealistic for
And this-
the vast majority of our
This has
users.
been one of my pet peeves for a while, and I know that, but I worry about just how effective is that letter,
Mhm.
because they get it and they're overwhelmed. I mean, I've often thought we need to have people that help members navigate, and you do, but you don't have enough people. So I've advocated for a bigger staff for you to get, you will. I mean, you really almost need people to help members understand that and make the right choices for themselves and overall for the program. And Brian, this is an area where you could spend a little money and you may save a lot more in the long run. So I think we'll have conversations in the future.
Yeah,
Hello, everybody.
I apologize. And again, we do have a medical individual on the SCBC, and I guess if I could go back in time, would like to have had a discussion, relative to the consequences from a medical standpoint, rather than strictly look at it from a financial standpoint. Although apparently we had no choice in the matter, but I guess moving forward, as these issues come up and the change in formula, and I'll be quite honest, I got caught in one of these changes in formulary several years ago, and it was terrifying. Now my doctor filed an appeal and I was able to continue to receive the medication. In the Zepbound cases, there were no appeals granted that I'm aware of.
There is an appeal process based on medical necessity.
Well, the problem there is that with this individual I spoke with last night, that dragged the process out longer for them until they were finally denied. So now they have to go back again to A to begin the Wegovy administration. So I'm not aware, and maybe I'm wrong, of any Zepbound appeals that have been granted.
So those are not managed by our office. To your point, we also are not clinicians and do not have the ability to review. So that is fully handled by CVS.
Yeah, well, regardless, I just wanted to bring the issue up, and I apologize for belaboring it.
Treasurer Davis.
I just really quickly wanted to, again, commend Stephanie, because she actually did do substantial research to kind of look into how exactly this change would affect people, and did sort of do a lot of that work, brought up a lot of concerns, and I think has been trying to be very conscientious in how this kind of moves forward. And I just have to say it, in an open public meeting, that truly there was a lot of effort put in.
Yeah, and I'm not trying to diminish SBO
Yeah.
in any of my comments
I don't
or
think
what
you
they do. I just wanted to raise the general issue about formulary changes and the need to be very diligent about how we manage these things. I would be curious if we could quantify. I know there's the rebate issue out there, but if state employees were given the option for an additional copay, what that copay might look like as an academic exercise.
I can tell you, if we were to continue covering Zepbound against the CVS formulary, we would be paying the full cost with zero rebates. It would be about an extra $15 million a year based on current utilization, not accounting for any new trend. For the members, if they were to cover that additional cost that is considered to be a loss from the state's perspective, it would be pretty close to that $500 that you would be paying direct from the manufacturer.
And it's $500 monthly.
Correct.
If we have to get to some trend some assumptions we're gonna vote on, right, Brian?
Yep, that's correct. So real quick on the screen, recall we reviewed these stats last month. No real changes on the medical side from the historical data. We simply got June results to close out FY25. So this is updated for the full fiscal year versus 11 months. Same story. Average prior 5 years on the Non-Medicare medical side was 8%. That's the same as the current assumption. So no recommended change on that assumption from 8%. On the Medicfill side, same exact results. The average prior 5 years trend was 6%. Last year, recall, we raised the Medicfill medical trend assumption from 3% to 5%. And now we're recommending a further increase from 5% to 6% for FY26. On the GLP-1 side for weight loss, the update is that we received June results. June had a significant increase over May, about a total of an 8% increase, such that the full fiscal year wound up about fourfold what FY24 was. So the year ended at 53.8 million, pretty close to what we had projected this time last year. Although going forward, we were sort of expecting a leveling off of the increases, and you can see the last 4 months alone, and really the last 7 months outside of February being an outlier. Month over month increases were 15%, 10%, 17, 4, 6, 8. So still pretty high month over month increases in really driven by utilization changes, not much of a change on the unit cost side. So going forward, we are recommending a trend assumption on the commercial side for weight loss. Ignore the 23% for a quick second. The underlying assumption is relative to utilization increases is 8% per month for the first 3 months of FY26, then 7% for 3 months, then 6 for 2, 5 for 2, 4 for 2. The 23% is reflective of the formulary change from Zepbound to Wegovy. So again, note these are gross costs before rebates, and Wegovy is a more expensive drug on a gross basis and a less expensive drug on a net basis. So on a gross basis, fully switching over to Wegovy would mean that July would be actually 23% higher than June, with the underlying, again, 8% increase in utilization. And this is what I'll call sort of scenario one in terms of potential recommendations for the SCBC to vote on. You can see under this scenario that FY25 gross spend of 54 million skyrockets all the way up to $137 million, but certainly not an unrealistic scenario, to say the least, based on what we continue to see, as well as sort of evolving indications that these drugs are used for. And then we have a little bit more aggressive scenario to review, where the underlying assumption goes from the 87654 to 5% for the first 2 months, 4%, 3%, 2%, 1%. And that scenario would reduce the projected gross spend from the 137 million down to the 108 million. Again, this 19% is the combination of the 5% utilization increase and the flip from Zepbound to Wegovy. In terms of an absolute recommendation, we are presenting the two alternative sets, although based on what we've continued to see through the back half of FY25, pressed to a recommendation, I would recommend the 8 down to 4% scenario as likely a more realistic scenario than this more optimistic 5% down to 1%. And then the graph on the right just simply shows how the two different trend scenarios would diverge over time. Even though we're asking the SCBC to vote on the trend assumptions for FY26, we do give a little bit of a longer term forecast in terms of where we think the drug spend might go over the next 4 fiscal years through FY29, and potentially eclipsing well over $200 million per year. In terms of this being an underlying component of the overall pharmacy trend, Last year, we presented this building block approach, which is how the FY25 trends were approved for pharmacy spend on both the commercial side and the EGWIP side. While we do show a forecast of rebate amounts, and this forecast reflects both the trend and the flip from Zepbound to Wegovy on the growth side, it also reflects anticipated higher rebates than previously anticipated due to the switch to Wegovy. Ultimately, it's the number inside the box that we are requesting the SEBC to approve. So the 38% weighted trend reflects that big jump in GLP-1s for weight loss from the 54 million to the 137 million, and then ultimately reflects a lower anticipated trend amount on the GLP-1 for diabetes side, and then really the balancing item of prescription drug spend at that same 9% that we have historically been using on the pharmacy side. So the amount looking to approval from the SEBC is to approve either this 38% weighted average trend under that 8% down to 4% utilization increase on the GLP-1 side, or 28%, which reflects that 5% down to 1%. And then lastly, similar type of a building block approach on the EGWIP side, but really it's only made up of two components. Gross cost outside of GLP-1s for diabetes because they're not covered for weight loss under the EGWIP, and then an anticipated higher spend on GLP-1s for diabetes for the same group of people, leading to an aggregate trend assumption of 11% on the EGWIP side. So again, sort of re-summarizing, we're looking for approval to maintain the 8% on the medical side, non-Medicare, meaning actives, pre-65 retirees, increase the trend on the medical side for the Medicaid population from 5% to 6%, in before rebate trend assumption of 11% on the EGWIP side, and one of the two scenarios on the prescription drug side on the commercial side of either the 38% weighted average trend or the 28% average trend. So obviously, before putting it to a vote, let me pause there and see if there are any questions from committee members.
I'll just comment, just looking at, everything seems pretty straightforward when you look at 1, 2, and 4. It's 3 that I kind of struggle with because there is this range. And since there is this range of like 23 to 33, like why wouldn't there be like consensus that we end up in the middle and it's 28? Is it something we can't model? Because like I don't want to be optimistic, but I also don't want to be overly pessimistic. So sometimes you kind of go with like a 50-50, and I'm just throwing it out there for a response.
Yeah, so there certainly isn't any utilization scenario that we couldn't model between the two. What are the ramifications of choosing one or the other or something in between, right? These are trend assumptions that once approved, we will use to set the FY26 budget. And to the extent that actual utilization comes in higher or lower, experience will be what experience is. FY26, the 4.2% rate action is already set. I don't know if Stephanie, you have any commentary to add relative to what the ramifications might be in terms of requesting a higher or lower budget approval from the state, because that's ultimately what altering these assumptions do. Because again, recall, claims will be what they will be, and we will run surpluses or deficits, and we're simply trying to propose assumptions that make the expected FY26 results as accurate as possible. But that doesn't mean that just because we're sort of looking out the rearview mirror, right, to predict what will happen in the future. And just because we've seen these month over month trends of, 4, 6, 8, again, 10, 15, 17, doesn't necessarily mean that we will see what's proposed here, but it certainly seems to be the most realistic based on the growth trajectories that we've seen dating all the way back to the beginning of FY24. And I would
Right.
simply view them as maybe couch them as a realistic assumption set and an optimistic assumption set.
Well, it depends if, this is Stephen, sorry, I didn't raise my hand. It depends, I mean, at some point, you would hope that this would peak, right? That you reach that point where, which I don't think we've, there's debate right now on whether the usage has peaked or not, but, it's one thing from a budgetary point of view. If you go too low, right, and your budget exceeds that, now you got to come up with the funds. If you go too high, it may be a little bit unfair to the people who have to, get the increases in terms of the co-pays and the premiums. I like the suggestion that Brian said about being in the middle. It kind of insulates you, not totally, but it gives you a little bit protection on both of those issues. That's just my opinion.
If I may, the rebates just drives me absolutely batty. And, saying, oh, that's our spend. Well, it's not really our spend. It's our spend before we get 40% of it back. Or, I mean, it's just, it so throws everything off. Are you saying that you need to come up with a percent for the total gross spend before rebates in your process for coming up with fiscal 26 budget, but you don't have to come up with a net spend after rebates projection?
Yeah, so the rebates projection, Representative Bomback, are a byproduct of the gross spend projection. So said another way, this sort of rebate line here that's in this summary, these numbers are dictated and predicated on these other components that make up the gross trend.
No,
So we are independently projecting rebates, but again, it's a formulaic byproduct of the approved gross trend.
And you've made the adjustments for which GLP-1 we're using because
Correct.
we get different levels of rebates depending on which one we're using.
Right. So you can see as an example in the top half of the section, again, this was the 8 down to 4 scenario. You can see that FY25 rebates were just about 110 million, and we're forecasting them to go all the way up to 160 million, or a 47% increase in rebates, which is heavily driven by the increased utilization of the GLP-1s for weight loss.
Okay. Oh God, I hate this. I hate this area. It's drives me nuts. Thank you. I'm thoroughly flummoxed by the whole universe here, but I appreciate your work on it.
It's a pleasure to committee. It's the day's getting older as we go here. I think the 33% figure is probably the most conservative that we could go with. We're really really talk, if you're looking at those numbers, Brian, correct me if I'm wrong, but it's about a $16 million gap between the assumptions at that 23 and 33. My idea of splitting the baby would give us in like an $8 million range, but I'm willing to punt that till the next time we kind of come up with these assumptions and dig down, and we'll have another year under our belt to see to this point of how we're getting as far as saturation of population on these, utilization of these. So I'd like to get a motion with regards to these recommendations, either at the 23 or the 33, the 33 being the more conservative approach to what we would experience. Anyone? Come on, Yvonne, help me out.
Okay, I move that, we take the more conservative approach at 33%.
And you're saying? And
I'll second
1, 2, 3 at 33 and number 4 at 9. So as
Okay.
stated
I'm
on
sorry,
that.
all
Yep,
four,
yep.
as stated.
Did I hear a second?
Stephen, second.
Okay. We have a motion and a second. Any discussion on the motion? Jeff Tashner.
Ease my pain. This is just for purposes of setting our budget for the coming year.
That's correct.
To measure our performance against it. And it's not going to translate into any kind of action in the coming year to increase the contribution rates.
No, because we're really gonna look at actuals. This is really just to
That,
try to
I just
set
want
a
to make sure
benchmark out
Yeah.
there.
that was my understanding, but I just wanted to confirm it.
That is correct.
He would have screamed otherwise.
Bill Overly?
And I wanted to second Paul Baumbach's input on the gross versus net. I mean, they're intimately tied together. You're projecting the gross, and you're also, as a result, you get the net figure. I've never quite understood why we've always dealt with the gross versus the net after rebates. So I'm kind of mirroring what Paul said in a different way.
Yeah, I think, Bill, it's a little bit of semantics, right? Either way, we are projecting rebates in the scenario that the gross cost is increasing by. So whether or not you're voting on a 38% trend gross or a 33% trend net, as compared to a 28% trend gross and a 23% trend net, it's ultimately the same answer.
Yeah. And it's in this budgeting process, rebates are considered revenue. And, the cost of the gross cost of the drug is an expense.
The claim,
And
yeah.
we actually do it the same way in Medicaid. That's probably part of the semantics.
Hopefully in our next CBM contract with more transparency, we can set aside the rebate issue.
But the prudent RX savings is listed as a negative revenue, am I correct? Sorry, a negative expense, negative spend, right?
Correct. Those
Why
are
can't there?
those are
why can't the
savings that,
rebate?
because the prudent RX savings actually comes through on the claims, comes through the claim side of the equation.
Because there's a time lag for rebates, it has to be treated as revenue and not a negative spend. Is that correct? Because the time lag between the claim and the receipt of the money, that's the difference between the prudent RX and the GLP rebates. And because it doesn't happen at the time of the claim, it has to be treated as a revenue and not a negative spend the way the prudent RX is. Is that what you're saying?
I'm not sure what the genesis is of the classifications into the different buckets that have been historically presented. It's just the rebates have always been presented in the other revenues category. Maybe it was done because of the lag. I'm not 100% sure.
Okay, thank you.
All right, we have a motion and a second. We had some discussion. Do we need to do a roll call or can we just do a voice vote? I'm asking for a voice vote on this one. All those in favor say aye. Aye.
Aye.
Those opposed? None. All right, assumptions have been approved. Can we do open enrollment next time?
Yes.
All right, so I'm suggesting that we point, agenda item number 9 to the next meeting, which leaves us to agenda item number 10, public comment.
So I did not have anyone pre-registered for public comment. I did have one person in person sign up. We do have Stephen LaPage here, so whenever you're ready.
Okay. First of all, I want to say I'm not a lawyer. Okay, but I'm going to talk about the PRC stuff. So if there were no contract, there would be no need to convene a committee. In my opinion, because there is a state contract involved, state contracts are governed by procurement law. So procurement law gives the agency, DHR, the authority to create a committee and gives the agency, DHR, broad discretion and flexibility over the makeup of the committee to allow anyone, including system experts, to serve on it. It doesn't even specify or limit the number of people that can be on it. The agency then creates the committee through the RFP, in which it names members to this committee. The power to create the committee is given by procurement law and to the agency, not to the SEBC. Therefore, it should not be considered a committee under the SEBC, but a committee created by the agency through guidance of the procurement law. And that's my comment. Thank you.
Thank you. Is there anyone logged in virtually that would like to make a public comment today? You can hit *5 to raise your hand if you're over the phone, or just hit the raise hand button. Hopefully everyone has one of those. Don't see any additional comment requests. I will turn it back over to Director Maxwell for other business.
Does anybody have any other business they would like to bring before the committee today? Okay, I'll entertain a motion to adjourn.
So moved.
I get a second?
Second.
All those in favor?
Aye.
Aye.
Opposed? Too bad. All right. Have a good evening, everybody.
Thank you.
Thank you.